Okay, I think we'll start. Anybody else that drifts in from classes can join us. Thank you very much for coming out, particularly today, which is always a difficult day. We have our guest today will be speaking Dr. Gideon Christian, who's come from Ottawa. Gideon has a really extensive and wide-ranging CV, which you can all access on the website, so I'm not going to repeat it all. But is a PhD in law from Faculty of Law at the University of Ottawa. He did his thesis on the sustainable legal framework for transboundary movement of electronic waste. He's a master's as well from University of Ottawa. He's a qualified barrister in Nigeria as well as qualified in Canada, and his LLB was from the University of Lagos. A number of significant awards during his graduate work, including the Bombardier Doctoral Award, a CG African Initiative Graduate Research Award, and a couple of thrown in as well from IDRC, just for good measure. He's been teaching part-time at the University of Ottawa in his graduate work and afterwards, but his actual employment and full-time job is with the Department of Justice in Ottawa, and if I get the team right, the name right, it's in the evidence management team, but focusing on e-discovery, and instead he does a significant amount of training for people coming in that area as well, and was previously for a while legal counsel in the international program section at Justice as well. The rest of his fairly extensive CV, and you might want to review some of the publications listed there as well. He's apparently got two jobs. He's working at Justice and has a night job writing in his areas of interest. Today he's going to speak on predictive coding, adopting and adapting artificial intelligence in civil litigation. I always know it's going to be cutting edge for me when the first two words describe something I don't quite know what it is, so I'm looking forward to finding out. Thank you very much. Please welcome Gideon.
Thank you very much, Professor Saunders, for the introduction. And I'd also like to thank you, the audience, for taking time out of your busy schedule to attend my presentation. I'd also like to thank the Schulich School of Law for inviting me to your wonderful School of Law and to the beautiful city of Halifax. I'm very happy and delighted to be here. I'm going to be presenting to you today a research I've been working on for a couple of months now. Started working on this research late last spring. And it has to do with use of artificial intelligence in civil litigation. So, my research will commence with a brief overview of the meaning and scope of artificial intelligence. Thereafter, I will review aspects of civil litigation where my research argues that artificial intelligence could be incorporated to complement the work of lawyers. Thereafter, I will go further to identify and address legal issues that need to be addressed in order to adequately incorporate this technology, or this alien technology, as a friend of mine called it, into a civil discovery. So, what is artificial intelligence? Simply, artificial intelligence is the science and engineering of making machines perform tasks which, when performed by humans, will require cognitive or human intelligence. There are many aspects of artificial intelligence today, or many areas in human life where artificial intelligence today has been successfully incorporated. We have from high-tech self-driving cars to basic face recognition technology in your Facebook account to even predictive texting or autocorrect in your smartphone SMS. There are many branches of artificial intelligence, but my research focuses on one branch, that is machine learning. Machine learning, it's a branch of artificial intelligence in which machines learn to perform and improve in the performance of a task as a result of performing same tasks over a given period of time. With adequate training, machine learning algorithms are capable of achieving results similar to, if not better than, that achieved using human or cognitive intelligence. A very good example that has been used to illustrate the basic feature of machine learning is the spam email analogy used by Professor Harry Southern in his work titled Machine Learning and Law. Now, who here has never ever received one of those annoying emails from online pharmacy offering to sell you drugs at highly discounted rates without prescription? What do you do with those emails when you receive them? Well, this is what I do. I mark them as junk email and then send them to my spam mail folder. But do you know that by doing that, you are actually training machine learning algorithm in your email service? Because what actually happens is that this machine learning picks up that email, analyzes the email, identifies the unique characteristics of that email, and learns from that analysis that any email possessing this or similar characteristics is a junk email. So next time when a similar email is arriving into your mailbox, rather than sending it to your inbox, it will automatically learn and identify it as a junk mail and then send it to your spam mail folder. That brings us to another aspect of machine learning, which is known as predictive analytics or predictive coding. Predictive coding is a machine learning process in which seed sets are selected, or in which predictive coding software is trained to identify and classify documents based on predetermined criteria. Predictive coding is now increasingly being used to review large sets of documents for the purpose of complying with discovery obligations in civil litigation. But before going into details of predictive coding and aspects of artificial intelligence, how it works or how it is not being applied in civil litigation, it is important to provide an overview of an aspect of civil litigation where this technology today finds applicability, and that is in the area of documentary discovery in civil litigation. Documentary discovery is a vital and important aspect of litigation process. The rules governing documentary discovery, depending on the jurisdiction at federal level, is governed by the federal court rules. At provincial level, it is governed by rules of civil procedure or rules of the court, depending on the province. These rules, or discovery rules, impose dual obligation on litigating parties, namely, obligation to disclose relevant documents in possession, custody, or control of the party, and secondly, obligation to produce relevant documents subject to a valid claim of privilege or statutory exception. So a typical document review or documentary review in discovery process will involve a two-stage review. The first stage will require identification or review of documents for purpose of relevancy, and the second stage will involve review of documents for the purpose of privilege, that is to determine whether the documents contain privileged information so as to exclude them from disclosure or redact the privileged information before disclosure. So a typical review will require on the part of counsel or lawyer knowledge of various types of privileges, including solicitor-client privilege, litigation privilege, negotiation privilege, as well as statutory exceptions such as those contained in Section 37 to 39 of the Canada Evidence Act. Privilege review is a vital aspect of documentary review in civil litigation because failure to identify privileged information will result in inadvertent disclosure and hence waiver of privilege, which may be barred for a party's litigating position or litigation strategy. Before the advent of modern technology, or in the good old days as we are told, documentary review took the form you can see here, review of large box of papers in a lawyer's office. However, things have changed today. 90% of documents today exist in electronic format. And the advent of legal technology, the advent of this technology has necessitated the need for legal technologies to assist lawyers to review documents for relevancy and privilege. So this gives rise to what is known as electronic discovery. This is one aspect of civil litigation where my research argues that artificial intelligence could be adopted to complement the work of lawyers. Prior to predictive coding technology, electronic document review took the form of keyword search and linear review of electronic documents. Although this was an improvement from the old school discovery we see on the screen, but it has limitations, especially where the volume of documents is large. So there arose the need for legal technology that will assist lawyers in timely and efficient review of large sets of documents running into hundreds and sometimes millions of copies in large litigation. And predictive coding today is the most effective and efficient technology or legal technology available for the review of large sets of documents in big and complex litigations. How does predictive coding work? By the way, predictive coding is also known by other names such as computer-assisted review or technology-assisted review. The first step in use of predictive coding for document review will require the development of what is known as seed set or training set. A seed set or training set is a sample document carefully selected by a lawyer from a larger database of data used for the purpose of training the predictive coding algorithm to identify similar documents. So the lawyer, having carefully selected this sample document, uses the sample document known as seed set to train the predictive coding algorithm. When the predictive coding algorithm has learned sufficiently enough to produce an acceptable result, the training or the software is now made to apply that algorithm to the entire database, classifying and coding documents accordingly on the basis of relevancy and privilege. The advantage of predictive coding lies on its ability to produce consistent and accurate results, far better than key other electronic search techniques or review techniques such as linear review or keyword searching. It also results in significant cost reduction in document review process, especially where the size of the document is large. So in the face of technology's changing landscape and the increasing number of documents that are now available for review, especially electronic documents available for review in a typical litigation process, it is now important for the legal profession to embrace this aspect of artificial intelligence technology in legal practice, especially in the area of documentary review. However, while this technology holds a great deal of benefit for the legal profession, there are certain legal issues that arises from the use of this technology which must be identified and addressed accordingly. My research identified and addressed two of these issues. The first is whether the use of artificial intelligence as opposed to human intelligence in discovery process, especially in document review, in civil discovery, complies with the rules of court or rules of civil procedure relating to discovery. To answer this question, my research embarked on a review of legal trend in various jurisdictions such as United States, United Kingdom, Ireland, before coming back home to Canada. Starting with US, the first case, that is the case of Da Silva Moore and Publicis Group, was the first case in which a US court was requested or required to approve the use of predictive coding technology for document review in discovery process. The document involved in this litigation was about 3 million electronic documents. The defendant sought to use predictive coding technology. The plaintiff objected to it, which was why it came before the case management magistrate. Now, at the time this case came before the courts in US, very few members of the bench were knowledgeable with predictive coding because this was a very new technology. So, but this case, the chief judge was very smart. He assigned this case to a magistrate known as Magistrate Andrew Peck. Magistrate Andrew Peck was one unique magistrate who was not only familiar with predictive coding technology. In fact, he has authored an article on predictive coding and had presented papers in seminars on predictive coding. So he was very knowledgeable in this area. And for proponents of predictive coding technology, this was a welcome development. In fact, at the case management hearing, the defense counsel who was seeking to use predictive coding was obviously excited that he was appearing before Magistrate Andrew Peck, that the magistrate turned around and asked him, I quote, "You must have thought you died and went to heaven when you heard that this case was assigned to me." To which the counsel turned back and said, "Yes, Your Honor." So Magistrate Andrew Peck reviewed alternative technologies available, such as linear review and keyword search. And he went ahead to approve the use of predictive coding in this case. And he gave reasons why he approved the use of predictive coding. And these reasons include, among others, one, the size of the document involved, which was very large. Secondly, the finding that predictive coding was better than other available alternatives, such as linear review or keyword search. He also talks about the cost effectiveness of using predictive coding as opposed to the other technologies. Also important was the defendant's transparency in the discovery process. In fact, the defendants in this case had agreed that they would be very transparent in their use of this new technology. They also agreed that they were going to disclose their seed set, that is the set sample document they use in training the predictive coding algorithm. They would disclose that to the opposing party. Though subsequently, we are going to see that disclosure of seed set is also another issue that needs to be addressed. So the plaintiff in this case, apparently dissatisfied with the decision, appealed the case to the district judge, arguing that predictive coding was unreliable and that it does not comply with federal rules federal rules of civil procedure. The district judge affirmed the decision of the magistrate, noting that there is no evidence that the use of predictive coding does not comply with discovery obligation under the federal rules of civil procedure. In essence, saying that the use of predictive coding complies with the rules of with the federal rules of civil procedure. So this was the first among many cases in which courts in US approved the use of predictive coding technology for document review in the discovery process. However, things took a different turn in the case of Progressive Casualty Insurance Company and Delany. In that case, the parties had agreed to use manual review to review 506,000 documents in the discovery process. The court sanctioned approved the agreement by the parties. Progressive began manual review of the documents. 8 months into the process, very little results has been achieved and cost has continued to skyrocket. Progressive unilaterally ditched the manual review without consent of the opposing party and approval of the court, began using predictive coding to analyze or review the documents. On a motion to compel, the court refused progressive use of predictive coding in that case. But it is important to note here that this was not an indictment on predictive coding technology, but rather the problem here was the progressive unilateral decision to adopt that technology as opposed to what was previously agreed upon without the consent of the other party or the approval of the court. So cases in US show beyond doubt that the use of predictive coding in discovery process is now judicially approved and sanctioned in various courts in that jurisdiction. And there is no reason to believe that that trend would change. Rather, the decisions in US courts with regards to use of predictive coding in document review has continued to blaze the trend in other jurisdictions, such as the United Kingdom. In UK, Pyro Investments and MWB Property was the first case in which an English court was required to approve the use of predictive coding technology in document review. The number of documents involved in this case was about 3.1 million electronic documents. Mr. Matthews, who noted in this case that there was no provision in the applicable civil procedural rules or practice direction of the court which prohibits the use of predictive of software such as predictive coding technology in document review. He cited and relied on the U.S. court decision, that is the case of the Silvermore and Publicis Group, and went ahead to approve the use of predictive coding in this case. And he also gave reasons for his approval, reasons that were very similar to that given by Magistrate Andrew Peck in the Silvermore, namely the size of the document, which is about 3.1 million electronic documents. The cost of manually reviewing the documents was considered to be unreasonable compared to using predictive coding technology. He also noted the absence of any evidence to show that the use of predictive coding technology in document review in this case will produce results less than that would have been achieved using other alternatives such as manual review. So for the first time, an English court approved the use of predictive coding in document review, and such same was also the case in Brown and BCA Trading. I also looked at the trend in Ireland, and the first case in which similar issue arose before an Irish court was the case of Irish Bank Resolution and Queens. The size of documents involved here was 670,000 documents. The plaintiffs estimated that with 10 experienced reviewers using traditional linear review, that it would take 9 months and 2 million euros to review the document, whereas use of predictive coding will only incur a fraction of that cost. The defendants opposed predictive coding, arguing that the technology does not comply with the rules of the court. Justice Fulham noted that the rules of the court contains no provision for adoption of either predictive coding or manual review in linear review in discovery process. And he noted that in the absence of any rule to that effect, that the court has an inherent jurisdiction to develop its own procedure to fill that vacuum. So he went ahead to order or approve the use of predictive coding in that case, stating, I quote, provided a party seeking to make discovery using predictive coding acts in good faith and a proposed system is transparent, opposition or non-cooperation by the requesting party should not deter the court from making an appropriate order. So having examined this trend, unanimous trend in this various jurisdictions, let's now come back home to Canada. Well, in Canada, the position is different, or things are different here. There is no clear judicial acceptance or refusal of predictive coding technology. And the reason being because we have never had any reported instance of parties litigating before the court or seeking to use predictive coding for document review before any Canadian court. In fact, a search of Canada Legal Information Institute, CANLI case law database using the term predictive coding, the most relevant case I was able to come up with was the case of Bennett and Bennett Environmental. And this case has to do with a corporate executive of a Canadian company who was facing prosecution in the United States for white-collar crime. So his counsel in U.S., defense counsel in U.S., used predictive coding technology to review large sets of documents that was dumped on him by the Department of Justice, the prosecutors. So the issue before the Ontario courts was whether the bill sent in by the defense counsel in U.S. was reasonable because the corporate executive was seeking to recover the cost from the corporation. So in that case, the courts held that the amount or the bill by the defense counsel was reasonable. So there was not really any explicit statement with regards to use of predictive coding before the court. However, it is important to state that even though we've not had any case law in Canada on predictive coding, that does not mean that predictive coding is not being used in Canada. There is at least one instance where the Canada Competition Bureau has approved the use of predictive coding by a merging company in order to comply with documentary disclosure under the supplementary information request by the Competition Bureau. Another issue which my research identified with regards to use of predictive coding in civil litigation is whether litigation privilege applies to seed sets. Now, if you may remember, I said earlier that seed sets are sample documents that are carefully selected by counsel from a larger set of database and used to train the predictive coding algorithm so that the algorithm can now be able to search the bigger database and identify relevant and privileged information. So the issue now is whether litigation privilege applies to this sample of documents selected by counsel. It is important to note that there is, in all the jurisdictions I've examined, there is no case law that has actually decided whether or not litigation privilege applies to seed set. This is still a huge legal vacuum. So in determining this issue or examining this issue, what I did was to look at first the purpose and scope of litigation privilege. And in the case of Blank and Canada, the Supreme Court of Canada noted that the purpose of litigation privilege is to ensure the efficacy of the adversarial process. And it noted that to achieve this objective, that parties to litigation must be left to prepare their contending position in private without adversarial interference or without fear of premature disclosure. With regards to the scope of litigation privilege, the Supreme Court also noted in Lizotte and Aviva that it protects against compulsory disclosure of documents whose dominant purpose is preparation for litigation. So, addressing the applicability of litigation privilege to seed sets will require a consideration of whether selection of documents from a larger database by counsel in the course of preparation for litigation gives rise to litigation privilege. A U.S. Court of Appeal in the case of Spock and Spell addressed this issue, though not in the context of predictive coding. The issue in that case arose from pretrial discovery. The defendant in that case disclosed thousands of documents to the plaintiff's lawyer. Before disclosure of these thousands of documents, they selected samples from that large database which they used to they used to prepare their witness for deposition. Now, after the disclosure, the plaintiff counsel came back to the defense counsel seeking that the defense counsel should identify the sets of documents, so samples of documents from that larger database they use to prepare the witness for deposition. The defense counsel refused to do that, asserting privilege over those documents, also arguing that the sample documents used to prepare the witness has already been disclosed to the plaintiff as part of the larger set of documents disclosed to them. The trial judge in that case held that that opinion work privilege does not apply to the documents selected, hence that the defendants were obligated to disclose or to produce identify the sample document they use. However, on appeal, the U.S. Court of Appeal for the Third Circuit held that the selection of document by lawyer in this case qualified for opinion work privilege and hence immune from discovery. In reaching that decision, the Court of Appeal relied on a quote from James Julian, Incorporated and Raytheon, wherein it was stated, I quote, "In selection and ordering of a few documents out of thousands, counsel could not help but reveal important aspects of his understanding of the case. Indeed, in a case such as this, involving extensive document discovery, the process of selection and distillation is often more critical than pure legal research. There can be no doubt that at least in the first instance, the binders were entitled to protection as work products. So imagine from the decision in Spock and Peel is the fact that litigation privilege may apply to counsel's judgmental selection of few documents from a larger population of documents for the purpose of preparation for litigation. However, it is important to note that that privilege will not apply to disclosure of that part of document along with the broader document set. So in this way, the seed set, if I may use that example in this case, become like a needle in a haystack. Whereas as a counsel, you are not obligated to identify the needle, you are obligated to turn over that needle along with the haystack to the opposing party. So in applying this principle to the issue before me, my research argues that litigation privilege may apply to seed sets for the following reasons. One, the documents were selected by lawyers in preparation for litigation, hence the dominant purpose test is met. Secondly, the documents were meticulously selected by the lawyer and hence potentially reflect the lawyer's understanding of the case, its opinion, and legal strategy. Third reason I gave is the fact that the disclosure of such documents may compromise a lawyer's litigation, it may reveal the lawyer's mental impression of the case and may compromise his litigation strategy. So these are three bases for arguments that litigation privilege should apply to seed set. However, looking at it the other way around, it may also be argued that no, it should not apply. And the reason the argument can be made in this other way is because seed sets will also be randomly selected, especially if you're using a software technology. The software technology can be programmed to randomly select documents, in which, in this case, it is not the lawyer's judgmental selection, it is just a random selection, and it does not reveal the lawyer's mental impression of the case. Secondly, even if the seed sets were judgmentally selected, in most cases, documentary disclosure comes at the very early stage of the litigation when counsel has not begun to develop litigation strategy. So, revealing the seed set at this point in time, it may be argued that, well, there is no really litigation strategy you are revealing because at this point, one has not been developed. Another problem with application of litigation privilege to seed set is the fact that it may pose a problem with regards to transparency requirements, which the courts have often insisted in order to allow parties to use predictive coding technology. If you remember the case of De Silva and Publicis, one of the reasons why the courts allowed the party to use predictive coding was because the party was transparent. The party agreed to share its seed set with the other party. So if litigation privilege applies to seed set, and the party says, well, I have privilege to this document, I have the right not to disclose it, will the court now say, well, for exercising your privilege over this document, you are not being transparent, and for that reason, I will not approve the use of predictive coding. So the argument goes either way. But the thing about it is that this is still a legal argument that is at developmental stage and can be conveniently looked at from two different ways. There is no judicial decision yet as to argue which way it will go. But in my opinion, I find stronger basis for making argument for the application of seed set application of litigation privilege to seed set, especially where those seed sets are judgmentally, carefully selected by counsel in the course of litigation. And I believe my time is up now. I think this would be a convenient point for me to stop and welcome questions from the audience.
Thank you very much, and I think we'll let you sort out the questions. I'll think about it. It was the training and algorithm, and I'm trying to get my head around still. I mean, you're whacking the algorithm on the nose, rubbing its face into the stakes or something. We have people who know this better than I do, so we'll open it up to questions.
Hi, Gideon. Thank you very much.
Thanks.
Very interesting, thought-provoking questions you've raised for me. One of the questions that I wanted to ask you about, which goes a tiny bit beyond but applies what you've done, is what about accidental disclosure and waiver? So under current rules, if you accidentally disclose a document and it's a genuine mistake, the other side has to turn it back to you. And our courts have said that if you're negligent, then you don't get that benefit, and the other side can rely on it as if it were waiver of privilege. Well, if you're going to use predictive coding, do you think that creates a risk for the disclosing party? The predictive coding algorithm will not catch something. You'll end up disclosing, you get a batch of 3 million documents. So you're going to end up disclosing a bunch of the things the predictive coding says are relevant but not privileged, but it makes a mistake, as humans will too. And you disclose something that's not privileged, it shouldn't be. Will you now be bound and not be able to get that back? Because it's hard to say it's an accident when you used a software, when you knew there was a risk, when you knew you picked the terms, you picked the seed set. If I'm a lawyer and you say to me, you can use predictive coding and it will save you time and money, but any screw-ups you're going to have to eat, is there an argument there to not use it for that reason? Are there arguments that you could still say it's accidental disclosure even though you've used predictive coding? What are your thoughts on that?
Oh, that's a very important question, I must admit. And let me start by saying the issue of inadvertent disclosure, it's inevitable, whether human or artificial intelligence, whichever you're using, it's a problem in both ends. And the judicial position has always been, well, if it was a honest, good faith mistake, you can get the document back. But if your negligence results in the disclosure, then you've automatically kind of waived the privilege. However, in the case of in electronic discovery, where parties are using electronic discovery technology, there's always an agreement they reach ahead of time. That agreement may contain a clause in it stating that in the case of what is known as a clawback agreement, stating that in the case we inadvertently disclose a privileged document, then we reserve our right to request that document back. So where there is a problem or inadvertent disclosure in this case, you cannot invoke that clause in your agreement to have the document back. So that can work. However, I must be sincere that the problem here is that if there is inadvertent disclosure and the other party has seen it and you successfully get it back, the only protection you have is that the party cannot tender that evidence in court. But what is seen has already been seen and cannot be unseen. There is no rule of law that prevents the party that have seen that privileged document from relying on what he has seen to modify his litigation strategy. The law does not prevent you from doing that. So everything boils down to, being able to train the predictive coding algorithm sufficiently enough to avoid such a situation from happening. But even in the case of human cognitive review, humans still have to be very careful and very conversant with various litigation privilege so as to be able to identify the document and exclude them from disclosure. So with regards to that problem can be handled by including a clawback agreement a clawback clause in the initial discovery agreement reached by the party before the use of predictive coding technology in the review. Yes, Phillips.
This may end in one part or it could be two parts.
Yes.
Is it fair to say that the other side will want to see the seed documents and maybe even the algorithms so that they can be reassured that the disclosure has been effectively conducted, that enough documents were encompassed that you didn't miss a lot of things that you should have gotten? That would be why they want access?
Yes, that's the reason they will want access, because predictive coding technology is new. So in most cases, parties are skeptical. Okay, if we allow artificial intelligence technology to do this work rather than humans, how are we sure that it will actually be able to capture all the documents? So in most cases, that issue will always arise, because they also want to know, how did you, since you're using artificial intelligence, how did you train the machine? What did you use in training the machine? So that we can be confident that you're not feeding garbage into the machine and machine is regurgitating garbage. So we want to be sure that the process used in training the machine is fair and transparent.
Yeah, and if that's the case, then isn't it really difficult? It makes it much more difficult to argue for privilege, because you don't know anything about the training of the algorithm if you don't have access to the seed documents and everything else that they used, and arguably actually access to the algorithm as well.
Yeah, that's actually true. There's a way to go about this problem, and one way to go about it is, rather than unilaterally developing the seed set, parties can meet together and agree on what documents to use to train the predictive coding algorithm. Because the whole idea of litigation privilege is secrecy. I need my space. But where the seat says it developed jointly between counsel, then there is no longer any need to apply litigation privilege. In fact, litigation privilege will not apply in that case. So that might be another way to go about the problem. Rather than unilaterally developing the system, have a joint meeting, agree on what to use to train the computer, the algorithm, and that will even give more room for transparency as well as acceptability of this technology. Yes, Rita?
Yeah, self-disclosure, I'm a computer scientist. If it doesn't matter, I can ask some questions, okay. Thank you. Yeah, I really love your presentation, and the topic is very interesting to me because of my discipline and all those things. And one of my questions is we actually believe that the future is going to be more of artificial intelligence and machine learning involved in things, but we still have that reservation that it's not perfect yet. It's still at developmental stage. There are still many tasks that cannot perform. So I'm just imagining, do we argue generally that predictive coding should be accepted in all cases? Or are there some cases where during the training set, the performance accuracy is below the threshold that we can say that it's not efficient at this point?
Yeah, that's a very good question. And like I said, my predictive coding uses machine learning algorithm, where the machine learns as a result of continuous training. So another important point in the use of technology, which has to do with transparency, the other party will also want to know, how did you train the machine? How often did the machine go through this process before you now apply it to the whole database? And the good thing about predictive coding is that when it is coding the document, it may give you threshold of relevancy. It may give you, okay, from 70% relevancy rate, this is the document you have, 80%, this is the document you have. So as a counsel, you now decide, okay, what do I go with? Do I go with 70, 80, or 90? Definitely you will not want to go with 30 or 40 because that will probably end up, that will be a bad one. So yes, the training of the machine is important. However, where it is evident that the training of the machine is not producing acceptable results, then definitely predictive coding will not be an appropriate technology to use in this case. And another thing is that where the size of the document is not large, predictive coding technology will not be the best. Human review may probably be the best, because the idea of predictive coding is that the document is so huge. If we are to use human review, we may probably spend years trying to review 1 million documents. So why don't we make life easy by using this algorithm? So that's important. So you have to look at the circumstances of the case to determine whether predictive coding is appropriate technology to use. I don't think predictive coding is an appropriate technology to use in every case. My research argues that it has its flaws, but when it comes to large set of documents, it is the best technology available for use now.
Okay, thank you. And I'm trying not to go more technical, but your answer actually brought in another thing. When we're talking about the number of documents to be reviewed being a determinant of the method to be used, it's more like saying that predictive coding and machine learning actually need data, a large data set for training and for prediction, right?
Yes.
So it advertently applies to say that if the data set is small, then you can never have enough data for training, and then for predictive, so it's obviously not going to be applied. Yeah, thanks so much. I love that.
Okay, thank you. Yeah. Yes, John. Hi.
Great. Really interesting presentation. I think it's a really interesting and challenging area. Two questions. One, I want to push you a little bit on, and this builds, I think, a little bit on what Professor Saunders and Professor Shapiro asked. I found it interesting that you decided, or in your opinion, you thought that probably litigation privilege should apply to the seat set. And I was wondering about whether you thought, because I actually fall on the other side, but I appreciate both sides of the argument.
Yeah.
I'm wondering, given the fact that this is a new technology or a new technological approach to an old legal problem, but I guess new to the extent that now we have more document-heavy cases because we've got the potential to digitize into large-scale mass litigation cases. So there's some skepticism about this approach that maybe, as Professor Saunders suggested, that if you're going through discovery, you're using machine learning algorithms, you're using seed sets, that People are skeptical as to accuracy. I know from my own legal practice that one of the often disputes from civil discovery, document discovery, is whether or not all relevant documents have been turned over, right?
Yeah.
And those documents listed in the annex as privileged, they're listed, but they're privileged, but they're not actually
produced,
disclosed. And I'm wondering, since this is new and there's questions as to accuracy, does it not make sense as a policy, a broader policy matter, beyond the interests of the individual parties in a given litigation, to err on the side of transparency until this approach is more widely used, more widely accepted within the courts, such that parties can see the accuracy. They have the seed set, they have the algorithm, they can see the documents that have been disclosed. And over time, more rules can be, sort of imposed with respect to the algorithm. But maybe transparency at this point makes a lot more sense with other kinds of electronic forms of new approaches to doing this kind of litigation emerge with new kinds of technology. So that's one question. I know there's a lot there.
Okay.
Maybe I'll let you answer.
Okay, let me take that. So I actually agree with you with regards to transparency. There are two. That's why I kind of try to present both sides of the coin, arguing why I think litigation privilege should apply to CSAID, and looking at it the other way also. Looking at it from a straight legal argument, you may have a very strong argument for applying litigation privilege to CSAID. And like you rightly said, this is a new technology. For us to move ahead, for us to actually accommodate this technology in legal practice, there may be certain things, sacrifices that has to be made. And the issue of transparency, because this is a new technology, parties are not very conversant with it. So when you come and you're proposing to use technology that even the judge and parties know very little about, and then you have something you are holding behind, a certain privilege, it's going to affect the acceptability of that technology. So yes, as a policy matter, I think it's important to be transparent, disclose the seat says, be transparent about the use of the technology, since people are not, litigants are not really very familiar with it, which will give them more confidence that yes, this technology will achieve acceptable result. So that argument can rightly be made. But however, in case of Biomet, which is one of the cases I listed, but I didn't discuss it, why this issue actually came up because the other party were seeking to get the seat set used by the opposing party. The court did not rule on the basis of privilege. What the court simply said, this is discovery within discovery, that it is not allowed in civil litigation. So Biomet that is refusing to hand over its seat set, the court said, look, a party's refusal to be transparent by refusing to disclose its seat set may exercise the court's may affect the court's exercise of its discretion. However, in this case, the court does not have the discretion to compel the other party to disclose its seat set. However, the court went on to say, encourage Biomet to reconsider its position on the seat set. So in this case, what the court is simply saying is that we cannot compel them to disclose the seat set. We do not think it is right for them to refuse to disclose it. However, we think they should consider their position to disclose it. So strong argument can be made on policy aspect of it that parties should be willing to share their seat set so as to make the whole process more transparent and also to make the technology readily acceptable. I don't know if that answers the first question.
Okay, just a quick second question.
Okay.
Thinking back to the different jurisdictions and their willingness or acceptance of predictive coding and discovery. And I'm wondering, maybe you could reflect a little bit more on the fact that, so you've got Canada's not yet judicially accepted. I know from my own research with respect to technology or new technological approaches, I find that part of the challenge is lack of empirical evidence as to the effectiveness of the technology or the technological challenge, or the effectiveness of the new technological method to answer legal questions or legal issues. And I'm wondering, are these differences that you've noticed here, at least with respect to Canada, is that a product of less judicial awareness about the effectiveness of predictive coding and its accuracy in discovery, and understanding amongst judges in terms of machine learning algorithms and automated processes? Or is this a product of these differences, a product of existing practices, existing rules of the profession in discovery?
Are you talking about Canada or other jurisdictions?
Canada or, Canada is different, but any other
Jurisdiction.
differences you've noticed in the jurisdiction?
Okay. Now, technology awareness is very important, especially when it comes to introduction of new technology. I think the first case in the US, which was the case of the Silvermore, suddenly became like a trend outside the US. And it's so fortunate, for the parties in that case that the judge that had this case was not just a judge who was totally novice to predictive coding, who probably could have been more skeptical than even the parties in authorizing to use it. Fortunately, the case came before a judge who was very familiar with the technology, who have written about it. So that made it much easier for him to approve it. So I think the issue of having knowledge about the technology will actually be able to impact or positively affect its acceptability in the profession. And once that case was decided, I found out that subsequent cases, both in UK and Ireland, that actually where the courts also have to face the same issue, now have to revert back to Magistrate Andrew Pegg in the Silvermore, sometimes giving reasons identical to the reason that he has given. In the case of Canada, we've not had any case coming before the court, so we don't know which way the court will go. But I think that considering the trend in other jurisdictions, if a similar case is to come before a Canadian court today, and a strong argument is made for use relying on the trend in other jurisdictions, I don't think I have any doubt that the court will approve its use in Canada. We're just waiting to see that case come up. And recently there has been increasing awareness of predictive coding technology. In Ontario, the Advocacy Society and Ontario E-Discovery Institute have been organizing a series of seminars for legal counsels and judges in this area. I actually attended one early this week, on Monday. So I think with the growing knowledge on the use of this technology, it will kind of gradually get rid of fear that we may have in accepting the technology. We are not arguing, I'm not asserting that the technology is a perfect technology. It's still a technology that is at developmental stage, that is continuously being improved. But come to think about it, even human review is not perfect. It's still, you still improve, with performance and more work in that area. Yeah. Thank you.
Are there any other questions?
Yes, Joe.
Just wondering a more technical question. Does the algorithm keep learning when it does the main run? I ask that because it seems to me that if it does, or if it can, doesn't that kind of diminish all the issues about the seed set, the importance of the seed set? If it continues to learn and if it has a way of identifying whether some of the coding it did early on may have been based on an incomplete understanding of the challenge, that it can then just rerun those, right? So, and if that's the case, who cares what the seed set is?
This is a software, depending on what's used. It depends on what software you're using and what are the features of such software. You may have software that kind of prompts you, even in one performing reviewing the larger database, prompts you for questions and issues which you need to resolve in order for it to continue. And you may have a case whereby, okay, the algorithm has just been trained, just apply it and then rank the document based on the rank of relevancy, whether 78. So I think the question comes down to what software you're using and what are the features of that software. But yes, that is a possibility. It can prompt you with questions while performing the task, and then you respond to it. Then the response will not determine it, and will also improve its learning process. But like you said, in such process, the issue of seed set, the relevancy of seed set, of course, continue to kind of diminish if that process continues. Yes.
The last question, undoubtedly the worst. Gideon, I thank you for explaining this. I teach in the criminal law area, and of course all of your precedents are from the civil law domain. Are you aware of any precedents in the criminal law setting? And, there's a reciprocal disclosure there, obviously, but sometimes in white-collar crime cases or cases where there's extensive electronic surveillance, there are massive amounts of documents. And I'm wondering if you've seen any use of this kind of technology in the criminal justice setting.
Okay. I work in the civil setting, so most of my experience has been on the civil setting. But that notwithstanding, The important thing I need to state is that predictive coding is not just for civil litigation.
Yeah.
Predictive coding is a document review software. So it doesn't matter whether it's civil. It's also used in even investigation, review of document for the purpose of forensic investigation. I gave an example of Canada Competition Bureau permitted its use for the purpose of documentary disclosure.
Yes.
Yeah, so it can be used in context outside civil litigation. If you also remember the case of Bennett and Bennett, the fact of that case had to do with a defense lawyer that was defending a Canadian corporate executive facing a white collar crime. Mm-hmm. He used predictive coding to analyze documents for the purpose of the criminal defense. So predictive coding applies to any document review where the size of the document review is large. Though my research is based on the civil aspect of it, but that does not mean that it is just limited to the civil aspect of it. It applies wherever there is a review of documents, especially large size of documents.
Thank you.
You're welcome.